battery just requires you to commit the act. We're not concerned with the result. We just want to know that you committed the act, which makes battery a general intent crime versus burglary, which requires a more specific intent. Now, I did mention before that the model penal code is where we will get most of our source of criminal laws from the model penal code as well as other statutes, but for the most part, we'll focus on the model penal code in this course. But before we do that, let's just back up here, because I was addressing all of the different ways in which you could try to prove mens rea. So we talked about intent, which is the general intent, the specific intent, the direct intent. But then there's also knowledge, okay? To knowingly commit a crime is not the same as intentionally committing one. In some cases, rather than intending to commit the harm, the defendant may only be required to know that the result is virtually certain. Some statutes even go so far as to add knowing or knowingly to the statute. For example, it is a federal offense to knowingly import any controlled substance into the United States. The addition of knowingly thus satisfies the mens rea requirement if it can be proven that you knew that you were importing a controlled substance into the United States. But what if someone doesn't know a crime is being committed, but he or she acts with deliberate ignorance or willful blindness? Well, in such situations, it is safe to say that the defendant acts with knowledge. So this is important because even if they don't know for sure that a crime is being committed, if they have a reason to believe that a crime is being committed, but they decide to willfully ignore it and not look into it just because they don't want to know, then they can still satisfy the knowing element. If the defendant, like I said, is aware of a high probability that criminal activity is taking place and or fails to make further inquiries as to whether this is the case, then the defendant can be held liable. This comes directly from your book, so you should have already read this. For example, if Lola agreed to drive Nancy's car from Mexico to the United States, she was suspicious that drugs were hidden within the car, and failed to confirm whether her suspicions were correct, then she would most likely satisfy the mens rea component of the underlying offense and be found guilty. So you see, in that example, she didn't know for sure that drugs were hidden in the car. She was suspicious that drugs were hidden in the car. She had the suspicion, but she failed to confirm whether or not her suspicions were true. In that situation, that's considered willful blindness or deliberate ignorance. And in that situation, you can satisfy the knowing element. Or you can establish mens rea with the knowing element. Negligence is another one. It is a common term in criminal law. Basically, it means that a person has not foreseen any possibility that harm would result. Negligence is concerned with taking careless risks. This means that negligence is a far cry from intent. Why? Instead of acting in a morally blameworthy state of mind, the actor instead fails to live up to some societal expectation. For a person to be held criminally liable for negligent behavior, it may be necessary to show that the negligence was wanton, very serious, or not how a reasonable person would have acted. So it is important for you to understand that an individual cannot be negligent and acted intentionally at the same time. Okay? Either you act intentionally with general or specific intent, or you act negligently. Now, an example of someone being held criminally liable for negligent behavior is driving and texting, which I hope that none of you ever do. Let's say, for example, someone is driving and texting, and for the second that they took their eye off the road to look at their phone and text, they knock over a pedestrian who was crossing the street, and then that pedestrian dies. They didn't intend to kill that person. It wasn't intentional, but it was negligent. Okay? This person was wanton. That's not how a reasonable person would have acted. A reasonable person would not be driving and texting. So someone who kills someone by hitting them with their car while they're driving and texting cannot be charged with first-degree murder for killing that person because they did not act intentionally. And as we know, murder requires an intent. You had to have acted intentionally. Then there's recklessness. Recklessness takes negligence to the next level. It has been defined as a conscious decision to ignore risk of which the defendant is aware. Put differently, an offender acts recklessly if he or she knows that a harmful result is likely, yet proceeds anyway. Consider a dangerous driving example. If George drives his Corvette through a residential neighborhood at 90 miles per hour, he is certainly acting dangerously, maybe even negligently. He is only acting recklessly, however, if he acknowledges the risks he is posing to others and shrugs them off. All right, so now we move on to the model penal code. And one of the reasons why I wanted to go through those examples for knowledge and negligence and recklessness is because we also see those in the model penal code definitions. So the model penal code names 4 mental states from most to least culpable: purposeful, knowledge, recklessness, and negligence. So with purpose, knowledge, recklessness, and negligence, these terms are sometimes embedded into the criminal statutes. So you're able to establish the mens rea by proving that a person acted purposely, they acted knowledgeably, they acted recklessly, or they acted negligently. And the reason why these mental states have been implanted into many of these statutes is because it's very difficult to prove what a person was thinking. It's very difficult to prove what someone was thinking. We can prove how they acted, but it's impossible for you to get into someone's head and know what they were thinking at the time that they committed this crime. So lawmakers have implanted these mental states into the criminal statutes, and prosecutors can use circumstantial evidence to establish purpose, knowledge, recklessness, and negligence in order to satisfy or establish that the mens rea element has been has occurred. So the first one is purpose. A person acts purposely when it is his conscious object to engage in conduct or cause a particular result. It is the most blameworthy state of mind. Knowledge, a person acts knowingly if he is A, aware that his conduct is criminal, or B, aware that it is practically certain that his conduct will cause a harmful result. A person acts recklessly with respect to a material element of an offense when he consciously disregards a substantial and unjustifiable risk that the material element exists or will result from his conduct. For example, if Johnny knows that it is unsafe to drive 100 miles per hour in a blizzard but does it anyway, he has acted recklessly. Johnny is consciously aware of the substantial and unjustifiable risk but disregards it. Finally, our least culpable state of mind is negligence. A person acts negligently with respect to a material element of an offense when he should be aware of a substantial and unjustifiable risk that the material element exists or will result from his conduct. The risk must be of such a nature and degree that the actor's failure to perceive it, considering the nature and purpose of his conduct and the circumstances known to him, involves a gross deviation from the standard of care that a reasonable person would observe in the actor's situation. Now, these mental states are in your text under this section titled Model Penal Code Definitions. I would urge you to read that and understand why the Model Penal Code mental states have been implanted in many of the criminal statutes. It is important for you to know that these things go to the mens rea elements of a crime, and it is important for you to also know the difference between purpose, knowledge, recklessness, and negligence. Okay, now slide 9 gives you examples of reckless, negligent purpose and knowledge. I won't go over them. You can go over them on your own time to get a better understanding of the four mental states. We then turn to strict liability crimes. And strict liability crimes do not require any type of mens rea, which I know may come off as confusing to you because we just said that in order for someone to be convicted of a crime, all of the elements must be met. There must be actus reus, there must be mens rea, and the actus reus and the mens rea must have occurred concurrently. There must be concurrence. But there are certain crimes where mens rea is not required, and those are strict liability crimes. An example of a strict liability offense is selling alcoholic beverages to a minor. If someone is charged with this offense, the state need only prove that the crime occurred. Intent is irrelevant. So if someone comes into my establishment, let's say I own a bar, and they have a fake ID that says that they're 21, but they're really only 16, and I serve them alcohol because I believe that they're 21, and I did not intend to serve alcohol to a 16-year-old because I would never do that. And it was my intent to only serve alcohol to people who are of age. And this person's ID said that they were of age. It doesn't matter. I can still be criminally charged with serving alcoholic beverages to a minor. Statutory rape or rape of an underage person is also a strict liability offense in many jurisdictions. Thus, and your book gives an example, when Mary Kay Letourneau, a 34-year-old Seattle school teacher, had intercourse with one of her 12-year-old students, she was guilty of statutory rape, even though she claimed that the boy was a willing participant. There's even more more statutory rape cases where, let's say, for example, someone who is of age, let's say the person is 21 and they have sexual intercourse with someone who is 15 years old, but this person looks like they're 19 years old